was to look at the existing technology, determine which of these tests are applicable to screening recycled water, mostly from a human health perspective. The exposure for recycled water is, the risk there is really toward the human consumer. Because we want to, our goal is to move this forward in a monitoring framework, we wanted to look at technology that was commercially available. We weren't interested in research methods that needed a lot of commercialization. So the tech transfer is always on our mind. And lastly, our goal for the project, the nuts and bolts, was to take these identified commercially available products and adapt that existing screening protocol into a water quality protocol and to test it and see how it worked with real recycled water samples. We put together a team of folks from around the country, cell biologists, analytical chemists, tox folks, and myself and Alvina at SWRCB from a water quality perspective. Over half of these folks are involved nationally and even internationally in terms of moving monitoring schemes for recycled water forward. So it's a very good group. They serve on EPA science advisory panels, so they're attuned to how these things work and what their potential for application is. As importantly, back when we started this project, the Water Reuse Research Foundation also let out a grant with similar goals in mind. And I believe that the Water Reuse California leadership was instrumental in supporting this work as well. Their project looked at the same technologies that we are looking at, but with a wider goal in mind. They were looking at research type products to see whether a greater amount of these assays could be used. So not the practical focus that we had, but together the two projects were very complementary. We actually formally formed a collaboration with them. We held 2 cross-project meetings in California to make sure that the experts were aligned in where the science was and how it should move forward. The endpoints that we found that were commercially available, we went and looked through the vendor list. We ended up with 3 vendors that offered products, and largely these endpoints are getting at the endocrine disruption side of CECs. As you can see, the first 4 or 5 are basically, will these endpoints screen for chemicals that affect reproduction in the end? Clearly, we're also interested, as always, in carcinogenic, cancer-forming chemicals. There are endpoints out there that do that as well. But this is the basic handful of tests that we evaluated in this study. Again, our focus was to make sure that to test the performance of these assays, but also with this focus on making sure that any such method can be transferred into the community. It does no good for very long, involved assays that require a bunch of nerds to run it. And so that was a clear focus of our project. Of the 3 vendors, we ended up selecting a product that was relatively unique amongst the other 2 vendors. This product offered by LifeTech was basically a frozen cell test product, whereas most of the other products out there, they're like pet fish. You have to keep them, feed them, keep them maintained. But this kit in particular, stick in the freezer, bring it out when you need it, run the test, and you're done with it. So it was a very attractive technology from our perspective. The performance of this particular kit was equal to the other vendors we tested, and we got very good cooperation and resources from the actual company to help us optimize that protocol. And we did just that. We took their technology and we developed a working SOP, if you will, for testing water extracts. And that water extract comes in on day one at the top there. You're basically adding dilutions of water extract into a plate of about this size, which has about 100 individual wells in it. So it's a high throughput method. It doesn't require very elaborate equipment. The equipment is very reasonable, and after 2 or 3 days, you have your answer on what that screening test told you. Very important for this project also to look at the robustness and repeatability, accuracy of these methods. We were able to establish some criteria that will help us understand if we're, quote, out of spec in results. We can look at individual criteria and determine whether it's the cell itself that's the problem, whether it's some chemical in the process that's the problem, and have this QA/QC construct to help us interpret these results. So after we established our protocol, we were on to the next big step, which was to actually test real water samples. Our collaboration with the SWRF folks allowed us to team up in an intercalibration exercise with, I think it was something like 20 labs worldwide participated. They brought their endpoints, we brought ours, our tests, and I'll mention the Australian leadership on that project in particular put this effort all together, a huge effort on their part. We ran our tests on, I think it was about 10 samples, and these were, again, extracts from actual samples from the recycled water train. So we've got the feedstock, which is basically secondary wastewater effluent, and then all the way down to the finished product water tested in this exercise. And our one test in particular that screens for estrogenic chemicals is what you're seeing here. The results clearly showed that we're able to screen the level of quality in those samples. First step checked off.
Oh, could you remind me what the dashed line represents?
So the dashed line is sort of a measurement threshold for that specific assay. So you see that drinking and surface waters, it's barely even detectable, the activity in that sample.
Is it analogous to a detection limit?
Yes, yes.
Or a repeatable result?
Exactly. The second result that we found in this exercise was to compare repeatability across labs. Clearly, a method is not useful if only 1 or 2 labs in the world can be proficient. So we showed in our team of 5 labs basically that everybody got the same profile for this screening for estrogenic chemicals. So check number 2, this protocol is repeatable. Okay, the last part of our project was to generate a strategy to actually analyze and interpret the results. Clearly, if the results give you a positive, negative only, well, that's of limited use. These assays will give you a numeric concentration. And that numeric concentration can, again, be used at a screening level to inform what we do with that result. And we've generated this basic framework. I think this framework is analogous to chemical screening, where you factor in uncertainty and you come up with some actionable level that you want to screen against with your tests. Interpreting those bioassay results, we come up with sort of a tiered response threshold. And the key here is you're taking these bioassay results, comparing it to the action level. Okay, if the action level is not exceeded, you just keep doing what you're doing. If you start to exceed that, then you need to investigate what's going on with that. And again, in the screening mode, we're not saying that you stop everything, but we're saying you take the appropriate action based on these test results, whether that's more chemical analysis, whether that's looking at the risk of what you're exceeding. But again, we're very much focused on this technology as a screening tool. So at the end of the day, we were very happy to find that specific screening test for estrogenic chemicals behaved very well. It gave us good results. We have a framework to interpret its results. And we were successful in taking that off-the-shelf product and adapting it for water quality testing. That was the only endpoint that we were extremely happy with. We tested a handful of endpoints. Some of those endpoints didn't actually respond to our samples, which may be good, may be bad. We just don't know yet. Other endpoints were even less successful. We didn't establish enough, quote, sensitivity for some of these commercially available endpoints. So we still need to look a little deeper to capture a more comprehensive toolbox for these tests. Where we want to go next with that successful test is to do a pilot evaluation. We want to bring the protocol and that screening test to the community, to the utilities, to the commercial labs to see what their proficiency can be with the same exact technology that we used. We want to test our framework to make sure that it actually gives us a sound decision-making tool. And then we want to incorporate the successes for that into the State Water Board certification programs to make sure that we have the written documentation to support moving forward with that. Some other next steps, I mentioned some of the endpoints weren't as successful. We want to continue looking at, from the research side, which endpoints are coming down the line and promising, and help optimize and adapt those again for this purpose. And then even down the line, drinking water is one issue we have, but receiving water is another. And these tests are just as applicable, if not more, to the receiving water environment as they are for drinking water. So with that, thank you very much, and I'm happy to take any questions.
I'm sure you will have questions. Thank you. That's a really important area of research, and while not everything, a really important piece, and really appreciate the work and attention on that. So I sense that Tam has something.
Well, thank you. Thank you. That was very interesting. I'm curious, though, what were the costs associated with these tests, especially the estrogen screening one, the one that you spent most time on?
Right. So we don't have a pinpointed cost, but the cost of running that particular test is probably about 1/10 of what a conventional analysis of, say, 100 to 200 chemicals are.
I don't know what that means. Give me a
Okay.
number.
Right now, we're estimating it to be about $100 a sample compared to $1,000 a sample. But remember that that's one endpoint, so we need a battery of these things.
Mm-hmm.
So again, we don't have a definitive answer on the cost comparison, but we certainly think it won't be more than the status quo, probably on the order of half when it all shakes out.
Let me jump in for a minute, because the point of this was to look at a large range screening tool that would give you, is there effects on the endocrine disruption in the cell line, to actually analyze for all the known endocrine disruptors would be hugely expensive. And that's, so each individual on just this endpoint allows you to identify, is there a problem or not? Then you would then need to go through a process of determining if there's a problem, what is causing that problem. So it's not so much that this test in and of itself is more expensive. It's not. By itself, it's much cheaper than doing this huge range of hundreds of different analyses. But if you find a problem, you may end up having to start doing more tests. So it's a difficult question to answer.
Isn't it also that you might need to do more tests, but you don't need to find out everything there is to know that you need another level of treatment, right? So the
That's
issue
right.
is just what's the most cost-effective way to, A, identify if you have a problem, and B, know when you need to trigger another level of treatment, which will
Yes.
take care of lots of things.
That's right. Yeah, that's right. And it also, in terms of environmental indicators, the bio effects is a more direct indicator of an environmental issue or health issue than measuring chemicals, just in terms of the hierarchy, so that if it can be attained, it'll give you more biologically relevant information. And I sense that in terms of the strategy of the team, getting to Board Member Dodek's question, looking, taking every step, it seems, to identify commercially available, low-cost alternatives, not having to keep the cultures going, but just take them out of the freezer, and all those steps really lead to a more cost-effective screening protocol. On the other biological relevant endpoints question, because obviously that's probably what folks in the audience that are interested in this, the stress response on glucocorticoid or the cancer and all those things. Is the water reuse effort in research and development possibly going to help us have more reproducible results in that area?
I'm not sure about reproducible, but they're definitely helped. Again, they cast a wider net, so we can go to school on some of these endpoints that are not yet commercially available, and the ones we evaluated. We evaluated, again, just a handful. They evaluated dozens.
Right.
And so they'll help us focus on which of those endpoints are ready to do an evaluation.
So be able to deploy screening efforts. I'm curious why the commercially available methods for these endpoints that are used by, for product registration, why is it that they aren't usable in these matrices? Does it have to do with the concentrations that we're dealing with and the sensitivity? How do we explain that they're good enough for project registration, but we only have estrogen effects that we can really use to screen our waters, whether in effluent or ambient?
I'm not sure I fully understand.
The question is,
The question
these methods are used to register products for consumer use.
Yes.
And so they're sensitive enough at a certain level to do that. And yet, in your review, you found that 5 out of 6 areas, we didn't have the tools available to screen waters.
Right. So for example, for pharma screening, okay, the doses for pharma are much higher than what you would see in a residual environmental, matrix. And so that's part of the reason. They've never optimized these technologies for lower levels.
Good. No, thank you for answering that. I think that's a key point.
I also want to point out that we early on focused on the most promising, which was endocrine disruption. So we focused our effort on that very early on in the project. So it's not so much that we failed, we focused on the one that we thought would be most successful, and were.
The test method.
The cell line. And so now the question is, we need to follow that up with much more detailed work on other endpoints.
And finally, I really appreciated the presentation. It was real clear as far as looking at different matrices. But one thing I didn't see was the topic we were talking about, the groundwater. Was there any effort to look at groundwater, screening ambient groundwater levels?
Groundwater per se was not part of our intercalibration, but once the groundwater is taken up into the system, we tested that.
Right, and just to add on to that, so as part of the recycled water policy, when it was adopted, there was an amendment to that where we do require monitoring of CECs for groundwater recharge of recycled water. So I feel like we can kind of get an idea of that world through results that we get from monitoring and sampling that the regional boards would require as part of their permits.
Thank you. Other questions?
Thank you.
Thank you very much. Thanks for the work. It's one of those journey of 1,000 miles.
You're welcome.
Begins with a single step, and this seems like a big one. So
It
thank you.
is, and I think this shows the good faith effort of, the SWRCB, our staff, and water reuse and all the partners, and here in California to really look at the long-term potential effects of our decisions to use recycled water. I think it's responsible, and I appreciate the care you've taken to make it a cost-effective approach. Thank you.
Thank you. Terrific. Before we move on to item 11, which is moved up ahead of item number 7, I am going to excuse myself from this conversation. I've looked at it. I don't have a legal conflict, but because of potential appearances and the fact that we have a full board here today, I'm going to excuse myself in an overabundance of caution. So I'm going to hand the chair over to Ms. Spivey Weber. Someone text me or something?
Are you, okay, sure, okay. What we'll do is we'll take a brief break after this item, and we'll find Felicia and bring her back in. I believe the Office of Chief Counsel will introduce this item, or Phil, will you? Oh, and James. Whoever is in charge can introduce this item.
Thank you. Good morning. Thank you. Good morning, board members. Is not on? So how's this?
Okay.
Much better. Okay. Good morning, board members. James Herring with the Office of Chief Counsel. This item is to consider a proposed water quality order considering a petition for review of the Tesoro Extension project. The San Diego Water Board denied waste discharge requirements for this project. The Tesoro Extension is a 5.5-mile toll road extension of State Route 241 from Oso Parkway to Cow Camp Road in southern Orange County. Originally, this project was brought before the Regional Board as the South Orange County Transportation Infrastructure Improvement Project, which was 16 miles starting from Oso Parkway and connecting to the Interstate 5 just south of the Orange County-San Diego County border. The petitioner certified a final environmental impact report in 2006. Application was submitted to the Regional Water Board for a water quality certification. That certification was denied for various concerns, water quality concerns, including a runoff water management plan, water quality mitigation, and anti-degradation concerns. The petitioner also was denied for a coastal commission permit, and that was in turn denied an appeal to the U.S. Department of Commerce. The petitioner then pursued the Tesoro Extension, which is the subject of this particular water quality order, which is the first 5.5 miles of that 16-mile stretch. They filed a report of waste discharge with the Regional Board in August of 2012. This particular 5.5-mile extension does not enter into a water of the U.S. nor the coastal zone. Therefore, the permit was a waste discharge requirements only. The Regional Board noticed a hearing in January of 2013. The petitioner then prepared an addendum to the EIR for the Tesoro Extension the next month. The addendum concluded that the Tesoro Extension generally followed the prior alignment of the South Orange County project, and that the Tesoro Extension would not result in any significant environmental impacts that were not already disclosed in the Certified Environmental Impact Report. Therefore, there was no need to prepare a supplement or a subsequent environmental impact report. Regional Board conducted a hearing on March 13th, 2013. At the hearing, it was limited to just the proposed WDRs because staff did not have time to adequately review the addendum and address CEQA concerns. During the meeting, even though they were discussing WDRs, there was some concerns about a little bit of a discussion on the CEQA as to what constituted the project. Region 9's counsel, circulated a memo just after the meeting asking the applicant as well as the public how the project was defined. The petitioner's board then approved its addendum in April of that year. Later, the Regional Board had a June 19th hearing that was focused on CEQA and the changes to the tentative order. Staff recommended adoption, but the majority of the San Diego Water Board members voted not to approve the tentative order. A petition was filed by the Foothill Eastern Transportation Corridor Agency. They alleged that the San Diego Water Board improperly denied waste discharge requirements because the San Diego Board believed that the CEQA documents were inadequate. In its response, the San Diego Water Board claims it denied the waste discharge requirements, but because of water quality concerns pursuant to its authority under Porter Cologne. The proposed order before you remands the matter back to the San Diego Water Board to provide the factual and legal basis for its decision. Upon our examination of the record, particularly the transcripts, it was unclear to us as to the precise reasoning for the Water Board or the San Diego Water Board's majority members' votes. The proposed order goes through CEQA and various authorities under Porter Cologne and discusses when a regional board or the state board may decline to issue WDRs for a specific discharge. It concludes that that the Water Board may look beyond the scope of what is submitted by the applicant and look at likely additional and/or future discharge associated with the proposed project. And it may request available information regarding future phases of a project associated with the pending application. It also briefly discusses the need for findings. The Regional Water Board in this particular case did not draft specific findings and relied on the transcript. This is when a pending waste discharge requirement application is before the Regional Board or the State Board for an individual applicant. This is a quasi-adjudicative proceeding governed by the Administrative Procedures Act, and there was a need to explain the factual and legal basis of the determination. The draft order, we received 16 timely comment letters, and I believe we're up to 7 late comment letters now. I'll kind of group those in threes. The petitioner, along with grouping of various Southern California governmental agencies, transportation authorities, et cetera, concur in the conclusion with the remand, but disagree with our conclusion stating that the Regional Board should limit its scope of review to discharge proposed only what's in the application of the report of waste discharge. They claim this is the new interpretation of Port of Cologne and will have adverse effects on linear projects, requiring transportation agencies to provide and obtain approval for discharges for all potential routes and future phases. The Save San Onofre Coalition, they generally support the order, but want the remand limited only to the adoption of findings, and that they claim that reopening of the proceedings would be inappropriate. Staff disagree and believe that this should be left up to the Regional Board's discretion. We intentionally drafted the order so that it neither required an additional hearing, but also did not prohibit a hearing should the Regional Board decide that it wants to have additional information submitted. Lastly, the Regional Board supports the order, but they did have a few language changes. The first one had to do with getting the Regional Board to rewrite or reformulate a portion or approve just a portion of the report of waste discharge, the application before it. Staff don't recommend adopting that particular change. We feel that this gets into the scope of the Regional Board rewriting the applicant's application for them. The second one concerned, thank you. The second one concerned an addition of a sentence to footnote 41, basically saying that adding the sentence, the San Diego Water Board must therefore presume the EIR, which includes the project description and the addenda filed with FETCA, complied with CEQA. Staff also disagree with that. While this CEQA itself says that the responsible agency must defer to the validity of an environmental impact report and a negative declaration, it's silent as to whether or not to give that deference to an addendum, and we could not find any case law or authority upholding the same level of deference to an addendum that we did not go through a public review. The last one has to do with a sentence that you'll find in the change sheet on page 9 regarding a rephrasing of a sentence that just basically parallels what's in the CEQA guidelines themselves. We did prepare a change sheet. Copies are in the back. In the change sheet, we'll kind of break that into 3 sets of changes for you. The first one are the normal typos, clarifications, etc. I did find an additional typo, just so everyone's aware of it, at the top of page 5. In the sentence that follows, footnote 15, it says the memorandum inquired as to how the petitioner defined of the project. Just scratch the extra preposition of. That was it. The other two, sentence you can see on page 9 is the sentence that the Regional Board requested, and that is, it should be towards the top of page 9, and it's the sentence that's marked off with footnote 42. And then there are 2 sets of changes. The first set, starting on the bottom of page 10 and going through the top of page 12, which basically is meant to clarify what our existing meaning was when we sent out the original version of the order, and kind of responding a little bit to the petitioner's concerns. And lastly, there are changes on pages 12 and 13 in the need for findings. Again, just clarifying what the original language is intended to mean and kind of giving some more prescriptive requirements or guidance to the Regional Board and to all water boards, frankly, that would find themselves in a similar situation. And that's my presentation, if you have any questions.
Any questions from board members? I have 20 cards. That's a lot. We will have 3 minutes per person. There are a fair number of folks who are together or hold similar views. It will help because we have a very full agenda for the rest of the day. It will help if you can even come in more efficiently under 3 minutes. But I will be much tougher than than my colleague on the 3 minutes. We can't. It will be 3 minutes.
Board member?
Per person.
Board Member Spivey Weber. I
Yep.
just wanted to point out that in the transmittal letter for this item, the parties to the petition were allotted 10 minutes to provide a presentation. So that would be the corridor authority, the regional board,
Oh, okay.
and that was all we limited. So everybody else would be limited to 3 minutes, but those two parties would have up to 10 minutes.
I have only one card that says 10 minutes, and it is Robert Thornton. Is that you?
That's correct.
Okay.
Correct. Yeah.
So who else has 10 minutes?
That would be the regional water board, so Mr. Gibson.
The Regional Water Board. Okay. Have you put in a card?
We did. We submitted, we broke it up 5 and 5 minutes.
Okay. Okay. Okay, so I will amend my, this makes it even more important that everyone who follows the next two presentations, that they keep themselves to 3 minutes or less. Mr. Naylor, would you introduce yourself? And, or, I'm sorry. Mr. Thornton, would you introduce yourself and do your presentation?
Yeah, thank you, Vice Chair Spivey Weber, members of the board. My name is Robert Thornton. I'm a lawyer with the Nossaman Law Firm and work counsel to the Foothill Eastern Transportation Corridor Agencies, which is a joint powers authority comprised of the County of Orange and elected representatives of 15 cities in the County of Orange. We were assigned 10 minutes, but in the interest of time, Vice Chair, I really don't think we will need to use the 10 minutes, especially in light of the revised draft order circulated on Friday. I think you have a card from Michael Kramen, the CEO of the Transportation Corridor Agencies. He's only here and will respond to board comments if you so desire. We would like to reserve whatever time we have for rebuttal if that's appropriate under your procedures. I will be brief, and I will intend to limit my comments to the revised draft order. Frankly, we're pleased with the staff revisions to the revised draft order. We do request one change, which I'll talk about. You have a number of comment letters from the transit and transportation community across the state of California. Your staff referred to letters from Southern California, but actually it's much broader than that. Includes the Metropolitan Transportation Commission of the Bay Area, the Los Angeles County Metropolitan Transportation Authority, and a variety of other transit and transit agencies that did have concerns with your original draft order because of language that suggested a rather dramatic change in the way that transportation facilities have historically been permitted in the state. It's described in detail in our letter, but without going into great detail, transportation agencies permit project on a phase-by-phase basis. This is how the high-speed rail project is being permitted. This is how the dozens of phases of the State Route 99 project is permitted. This is how the light rail projects in Southern California are permitted, and precisely the same procedure that the Transportation Corridor Agency followed. As I indicated, we're pleased. We can't speak for the rest of the transportation community, but we are pleased that the revised order, we believe, makes it clear that regional boards should limit their review to the discharge for the phase of the project proposed by the Transportation Agency unless the regional board makes a determination that it is unable under its Port of Cologne authority to exercise regulatory control over future phases. Frankly, given the breadth of regional board authority, the very significant number of statewide orders that regulate discharges from transportation projects,
we don't believe a regional board can reasonably make that finding. So we're pleased with those changes, and we support those changes. We certainly concur with your staff's finding that the regional board majority did not comply with state law because they did not adopt any written findings explaining the legal or factual basis for the decision of the 3-member majority. As we pointed out in our comments, this is not a new requirement. Over 40 years ago, the California Supreme Court made it clear in the Topanga decision that agencies, when acting in a quasi-judicial capacity, are obligated to make written findings. The regional board didn't do that. And beyond that, your staff has concluded that it's simply not possible to discern the reasoning of the majority of the regional board for the denial of what was a recommendation for approval by the regional board staff. In light of that failing, it is our belief that the state board should not only remand the matter back to the regional board, but that you are obligated to vacate the regional board decision and to order the regional board to reconsider its determination. In every reported decision since the Supreme Court Topanga decision in 1974, every reported decision involving a quasi-judicial agency, the courts have held that the appropriate remedy is to vacate the underlying agency decision. And the reason the courts have reached that conclusion is because they've made it clear that it's not appropriate for agencies to use findings as simply a basis for a post hoc justification of the prior decision, that they have to engage in a serious reconsideration of the facts and the applicable law. We think it's particularly important here because of your staff's interpretation in the revised draft order that we think makes it clear that the regional board should limit its review unless it can make the finding that it's unable to regulate future discharges. Clearly, that was a consideration that was never considered by the 3 members of the majority, and therefore, we do believe that it really is important and necessary to vacate the regional board order and to order them to reconsider it. I will conclude our comments there unless board members, you have any questions for me at this time.
Thank you very much, and thank you for coming in under 10 minutes.
Yes.
Thank you.
And if possible, I would like to reserve some time for rebuttal at the end.
Michael?
It's especially
Is
in
that-
light, Vice Chair, the fact that we have consolidated our
No,
side
no,
of the comments so that I'm the only spokesperson.
No, I get it. I get it.
It really
It's
is
mostly a procedural thing.
the discretion of the board. I mean, you all are accustomed to other proceedings where you will call back up parties to it just to provide clarification in light of
Okay.
statements that have been made. So.
Okay. We will do that. Thank you.
Thank you.
Yeah. The next speaker is Nathan Jacobson. Nathan, you don't look like yourself. You've grown taller.
Only looking better, I hope.
Yes.
I'd like to speak first, Vice Chair, if that's permissible.
Introduce yourself.
Thank you. Good morning, Vice Chair Spivey Weber, members of the board. Thank you for this opportunity to address you in this matter and for your recognition of the complexities of regulating linear projects like this one. On behalf of the San Diego Regional Board, allow me also to thank you for your guidance and the opportunity upon remand to add substantive findings to clarify the Regional Board's intent in denying the waste discharge requirements for the project variously described by TCA, the Transportation Corridor Authority. The San Diego Water Board has also asked me to reassure you that we do indeed regulate multiple phase projects. We are doing so, in fact, right now on the I-5 widening with Sandag and Caltrans and with the Rancho Mission Viejo development. And our ability to do so, however, is contingent upon a sound understanding and honest disclosure of the full project by the applicants. The board has also asked me to convey what I'm sure is a shared sentiment, that we get this right, and that statewide, and that you allow us to address the specific issues in this project. What made this project, however, different from the other multiple phase projects I mentioned and some of those referenced by the petitioners? One striking difference is that those projects have been fully described. The Water Board was not left to guess at future alignments, nor, as you pointed out, to put blinders on as to the future consequences of those projects. Simply put, the Water Board was compelled in this case to ask repeatedly, what was the project? And they received different answers depending on who they talked to and at what point in time during the hearing they talked to them. Simply put, the Water Board must have adequate information on the impacts. No project is without them for the whole project. In particular, it's worth noting that in this project, a 16-mile toll road connecting Highway 241 with I-5 in San Diego County was adequately described at one point in 2006, and it was rejected. The Water Board was preempted by the Coastal Commission, but that did not belay our fears and concerns for the water quality and beneficial use impacts of this project, the 16-mile project, would have had if approved. Indeed, the subsequent artful segmenting of the project into the Tesoro extension and future alignments to be named later only heightened our concerns, and our response to the remand will demonstrate factually the basis for those concerns. So is the Tesoro extension really a standalone project? If so, it's an over-engineered project, an oversized one, and the message that the investors, the public officials, and the public have been given by the Transportation Corridor Authority all along has been that it's not in fact a standalone project, that it is a piece of a larger whole. And indeed, their arguments in response to the petition continue that essential theme. Contrary to the assertions that this is simply a common practice across the state, subsequent segmenting of the whole project into the Tesoro extension and future alignments to be named later is not in fact good planning in following traditional practices, but rather an artful dodge. The Tesoro extension should not be seen as a limited effort, but an integral piece of a whole plan. A plan with demonstrable threats to water quality and receiving water beneficial uses that has been properly rejected by the California Coastal Commission, the Federal Commerce Department, and the Water Board. Nor is a toll road the only option here. The planning maps for the Rancho Mission Viejo development, Planning Area 2, include a county road option, F Street, along the same alignment, that could service the planned development in that area. It doesn't have to be a toll road, and that option does not carry with it the baggage of future alignments to be named later to the I-5, crossing sensitive high-quality waters and impacting coastal high-quality waters. While the Water Board is supportive and appreciative of the tentative order overall, the changes introduced in the change sheet do cause us some concern. These changes may, in fact, unintentionally constrain the Regional Board's actions in future matters and inappropriately shift the burden regarding water quality impacts from the discharger to the Water Board. I would like to ask that Mr. Jacobson next outline further our concerns and suggest clarifying language in the tentative order for your consideration. Once again, on behalf of the San Diego Regional Water Quality Control Board, we thank you for this opportunity and support the remand order and look forward to being able to address the concerns that have been raised in the petition and your response. Thank you very much.
Thank you, Nathan Jacobson, counsel for the San Diego Water Board. Right now, we're circulating a copy of the proposed changes that we are requesting that the board makes to the order. So as Mr. Gibson stated, the Regional Board generally supports the order, but has some concerns over these late changes that were made. The Regional Board interprets the changes as leading to some potential inconsistencies in the order, particularly in applying the standards that a Regional Water Board must meet when denying WDRs for a phased project. As I said, we have a few minor suggested revisions which would address our concerns and we believe provide consistency and clarity to the State Board's direction on this matter. The first requested change is simply to strike one word, and that's on page 11, the first paragraph. And that's strike the addition of the word readily. The way that the clause reads is when future phases of a linear project are likely to occur and may have water quality impacts, a regional water board may request that the project proponent provide any readily available information on those future phases. We believe that the insertion of readily creates a somewhat unclear standard for the regional board